In May 2010, a steam boiler ruptured inside the engine room of the MV Lissy Schulte, severely injuring a seafarer. He was immediately medically repatriated to Manila, where he underwent months of extensive treatment for cerebral concussions, fractures, and severe burns. When the case reached the labor tribunal, he was awarded standard partial disability benefits. But the Court of Appeals intervened, overturning that decision and awarding him the absolute maximum, $60,000 for permanent and total disability. This $60,000 gap exists because of a common misconception about how time and disability legally intersect under standard maritime contracts. There is a widespread professional belief that if a seafarer is physically unable to work for more than 120 days, they automatically become entitled to permanent total disability payouts. This diagram illustrates the law. The top timeline dictates the statutory deadline for a physician's assessment, while the bottom tracks the duration of the seafarer's physical incapacity. The 120 and 240-day rules strictly govern that top assessment deadline, not how long the seafarer remains injured. Confusing these two distinct legal concepts results in manning agencies paying maximum disability benefits for injuries that only qualify as partial under the law. To resolve this specific dispute, the Supreme Court of the Philippines stepped in, delivering its ruling in BSM Crew Service Center against Lanita. To understand exactly where the Court of Appeals failed, we must strictly apply the Elberg jurisprudential framework directly to the seafarer's medical timeline. A company physician has exactly 120 days from repatriation to issue a medical assessment. If further treatment is needed, the law extends this up to a 240-day hard cap. Failing to issue an assessment within this exact window automatically presumes permanent and total disability. The trigger for this maximum liability is the absence of a timely assessment. It is not triggered by the seafarer's ongoing need for physical therapy. A manning agency's financial liability hinges entirely on mapping their doctor's formal evaluation onto this specific statutory grid. The legal clock started the moment Lanita was medically repatriated on May 21, 2010. By day 84, the company-designated physician issued a medical assessment, logging a specific finding of partial disability. Because he required additional rehabilitation, the timeline cleanly entered the justifiable extension period toward 240 days. Then, on day 127, the doctor finalized the evaluation, reiterating those exact partial disability grades. Because a definitive partial assessment was issued well within the legal window, the presumption of total disability is defeated. A timely partial disability grading completely shields the employer from maximum compensation claims, regardless of how long the seafarer takes to fully heal. The Court of Appeals, however, made a critical mistake in their timeline analysis. They claimed the final assessment occurred after the 240-day window had already closed. The appellate court built its ruling on this flawed timeline. They relied on a letter dated February 11, 2011, day 266 from repatriation. But the factual record shows this February document was not a new medical evaluation. It was merely an administrative reply to the company counsel who asked for an update on the case. The text of that letter simply restated the original findings from day 127, noting they were submitted for your perusal. Using a reiterative administrative update as the legal reckoning point for a medical assessment constitutes a grave abuse of discretion. Appellate courts cannot artificially push the assessment timeline beyond 240 days by using non-medical administrative correspondence. If a timely partial disability grading is issued, how does a seafarer legally dispute it? The law requires them to consult their own doctor of choice. If those medical findings conflict with the company's physician, the dispute must be referred to a third doctor for a final resolution. Lanita did provide counter-evidence. He submitted a medical certificate from his private physician, Dr. Tay, but he obtained it during a single visit while his labor complaint was already pending. Evidentiary weight matters. The court had to balance the company doctor's multi-month evaluations against Dr. Tay's single visit pro forma certificate. Dr. Tay's report stopped short of a total disability claim. He only recommended further physical therapy, never explicitly declaring Lanita unfit for work or permanently disabled. Without an explicit declaration of total disability from their own doctor, a seafarer completely fails to discharge their evidentiary burden to challenge the company physician. The procedural architecture of this appeal is exactly why the Supreme Court stepped in. It was filed as a petition for certiorari under Rule 65 of the Rules of Court. Rule 65 imposes a strict boundary. The Court of Appeals is forbidden from re-evaluating factual evidence unless the lower labor tribunal acted with grave abuse of discretion. The NLRC's reliance on the Day 127 medical assessment was entirely supported by substantial evidence. There was no abuse of discretion to correct. The Supreme Court held that the appellate court overstepped its bounds. The CA decision was reversed, and the Labor Tribunal's partial disability award was reinstated. For manning agencies, this case underscores a strict operational requirement. Company physicians must finalize medical assessments within the 240-day window, regardless of ongoing physical therapy. In standard maritime employment disputes, legal liability is dictated by strict statutory deadlines and precise medical terminology, not the mere passage of time or sympathetic assumptions of incapacity.